In a political climate charged with tension, former President Donald Trump has taken aim at a new target: prominent law firms. Trump accuses these firms of weaponizing the legal system against him, alleging they have used their resources and influence to unfairly target him and his administration. The firms in question are among the most prestigious in the country, representing a who's who of powerful clients, from Fortune 500 companies to high-profile individuals. Trump's weapon of choice? Executive orders wielding the power of the presidency to enact sweeping measures against his perceived enemies. These orders are designed to cripple the targeted firms, cutting them off from lucrative government contracts, stripping their lawyers of crucial security clearances, and barring them from even setting foot in government buildings. The message is clear: challenge Trump and face the consequences. These actions have sent shockwaves through the legal community, with many lawyers and legal experts expressing deep concern over the potential ramifications for the rule of law and the independence of the judiciary. The firms targeted by Trump are not small-time players. They are giants in the legal field, representing clients across a wide spectrum of industries and political affiliations. The very foundation of the American legal system, the principle of equal justice under the law, is being called into question. The fear is that Trump's actions will have a chilling effect on the legal profession, making firms hesitant to take on cases that might put them in the crosshairs of a vengeful former president. In the face of Trump's aggressive actions, a formidable force has risen to challenge him: former solicitors general from both Republican and Democratic administrations. These legal heavyweights, once tasked with representing the United States government before the Supreme Court, are now using their considerable experience and expertise to defend the very institutions Trump seems intent on undermining. But who are these solicitors general, and why should their voices carry such weight? They are the elite of the elite, the top lawyers in the country, entrusted with arguing the most complex and consequential legal cases before the highest court in the land. They are the defenders of the Constitution, the guardians of the rule of law, and their opinions carry immense weight within the legal community and beyond. Donald Verrilli, who served under President Obama, has emerged as a leading voice in the fight against Trump's executive orders. Representing Sussman Godfrey, one of the targeted firms, Verrilli has filed a flurry of amicus briefs, legal documents that aim to sway the court's opinion on behalf of hundreds of firms. He argues that Trump's actions represent an unprecedented threat to the very fabric of the American legal system, undermining the separation of powers and jeopardizing the delicate balance that underpins our democracy. Paul Clement, who served under President George W. Bush, has also taken up the mantle of defending the legal profession against Trump's overreach. Representing WilmerHale, another firm in Trump's crosshairs, Clement has been vocal in his condemnation of the former president's actions, calling them a palpable threat to the separation of powers and a blatant attempt to silence his critics. At the heart of this legal battle lies a fundamental question: can a former president use the power of the government to punish his perceived enemies and silence dissent? The former solicitors general argue that Trump's actions strike at the very heart of the rule of law, a cornerstone of American democracy. The rule of law, a concept enshrined in the Magna Carta and woven into the fabric of the United States Constitution, dictates that no one, not even the president, is above the law. It ensures that everyone is subject to the same laws and legal processes, regardless of their power, wealth, or social standing. Trump's executive orders, however, seem to disregard this fundamental principle, targeting specific law firms based on their past clients and political affiliations. This unprecedented move has sent shockwaves through the legal community and beyond, raising concerns about the potential erosion of democratic norms and the chilling effect it could have on free speech and the right to legal representation. The fear is that if Trump is allowed to punish law firms for representing clients he deems unfavorable, it will set a dangerous precedent, emboldening future leaders to weaponize the legal system for their own political gain. The battle between former President Trump and these legal giants is not just a legal squabble. It's a fight for the soul of American democracy. It's a clash between the power of the executive branch and the independence of the judiciary, a test of whether the principles of the rule of law and the separation of powers will withstand the pressures of partisan politics. The implications of this case extend far beyond the legal profession. If Trump is successful in his efforts to punish law firms for representing clients he dislikes, it could have a chilling effect on free speech and the right to legal representation for all Americans. It could create a climate of fear and self-censorship, where individuals and organizations are hesitant to exercise their constitutional rights for fear of government retribution. This fight is a stark reminder that democracy is a fragile thing, a constant work in progress that demands vigilance and active participation from all citizens. It's a call to action for all Americans, regardless of their political persuasion, to stand up and defend the fundamental principles upon which our nation was founded. The rule of law, the separation of powers, and the right to a fair and impartial justice system are not mere abstract concepts. They are the very pillars that support our democracy, and they must be protected at all costs.